Good morning, and thank you all for joining us in our live webinar, our annual immigration date on this grey November day. Let us first look at some housekeeping points. This webinar is being held remotely, so please do bear with us should we experience any technical difficulties. We will aim to resolve these as swiftly as possible. We've been doing this for some time, so fingers crossed we don't have any. Our webinar will be an hour long, and we will dedicate 15 minutes at the end to ask your questions. All participants will be on mute throughout the webinar, and if you have any questions, please pop them in the chat box, which is on the platform, and we will aim to answer as many as we can at the end of the webinar. If we cannot answer any, we will get back to you by email afterwards. There will be some polls, so there will be some interaction from yourself, so please do get involved. Additionally, the slides from our webinar are in the handouts section, so please feel free to download these at any time. And finally, the webinar is being recorded, and the recording together will be sent to all participants a little bit later on today. One other point, we do have a short survey, which will pop up automatically at the end of the webinar. Your feedback will help us greatly with future events and any topics. And for those of you who complete the survey, as a thank you, you will be entered into a prize draw for a £50 John Lewis voucher, which may come in useful for that Christmas shopping, dare I say. Now let's move on to the introductions. For those of you who are joining us for the first time, I'm Imelda Reddington and I'm Head of Immigration at Field Seymour Parks. I've been with FSP for just over 4 years now. Today, I will be joined by Callum De Freitas and Victoria Unsworth, both solicitors in our immigration team. At FSP, we have over 100 staff and we service clients all over the UK. Many of our firm's regular clients are based in the Thames Valley corridor. However, with immigration clients, they are quite often national or even based overseas. FSP offer a tailored approach and we offer practical legal advice to our clients. We also offer free seminars, webinars and podcasts at regular intervals throughout the year across most of our practice areas. And in immigration, we offer bespoke training and workshops for some of the more complicated processes, such as right to work, sponsor license compliance, and we also offer a tailored administration service to assist registered sponsors with the management of their sponsorship license and the migrants' visas. So please do let us know if we can assist you with any of our services. Our contact details will be on a slide towards the end of the webinar. Let me introduce the topics for today. So this is our first immigration update of the year, so there have been many changes to the immigration rules this year. So what's new, you might ask? Firstly, I will talk about the immigration rule changes since the beginning of the year, and then I will look at the sponsorship updates, which will probably impact a number of our listeners. This session will take approximately 40 minutes. Then I will hand you over to Callum, who will do a recap on right to work checks. This will take about 10 to 15 minutes. And then back to me to talk about the new Electronic Travel Authorisation Scheme coming into force next year and the year after. And then I'll look at what's in store for immigration next year and beyond. That will take another 10 minutes. Victoria will be running our polls today. So get your fingers on the buttons. It's over to you, Victoria.
Thanks, Imelda. Good morning, everyone. So we have our first poll here, which is, if you are a sponsor, when did you register for your licence? And the options are that you're not currently a sponsor, before 2020, between January 2020 and January 2023, or after January 2023. So there is no right answer to this question. It's just for us to get a feel of who's listening. So most of you are currently not a sponsor, So that'll be interesting for you to see the updates. And then we do have a few sponsors in attendance as well. So I'll hand back to Imelda for the next slides.
Thank you, Victoria. We have an interesting mix of attendees. Right, so let's first look at our immigration rule changes. Increases to the visa application scheme came into effect on the 4th of October. Work visas and visit visas have gone up by 15%, whereas family, settlement and citizenship applications have gone up by 20%. Student visas have gone up even more by 35%. Now, of particular interest to you, or some of you, will be the skilled worker application and the global business mobility visa applications. Applications from overseas have increased to 719 for a 3-year visa and 1420 for a 5-year visa. These are up from 625 and 1235 respectively. In-country applications have gone up. It will now cost $827 for a 3-year visa and $1,500 for a 5-year visa, up again from $719 and $1,423 respectively. The fees for assigning certificates of sponsorship increased also from $199 to $239. And there will be a significant increase in the immigration healthcare surcharge at 66%, which will affect applications for most visa applications, including skilled worker, global business mobility, and many others. This fee will increase from a whopping $624 a year to £1,035. This is per year of visa application. For children, students, dependents, and youth mobility scheme applicants, the fee is slightly lower at $470 to increase to $776 per year. Now, we are still waiting for confirmation of when exactly this change will come into force, but we expect it to be around the 16th of January 2024. So just to give you an example of the cost of a sponsored worker visa in some of the routes I mentioned. So a 3-year visa will come in at £7,163, whereas a 5-year will be nearly £12,000. This does not take into account dependent children, partners, visas, nor does it look at professional fees or any other fees that may be associated, such as translation, TB certificates if applicable, etc. Rest assured, our fees are not increasing at this time. However, you will see that the cost of recruiting migrants has gone up significantly. So for those of you who are sponsors, and I know that is a small proportion of our listeners, please do revisit your immigration and recruitment budgets, taking into account of these increases, particularly for the start of next year. We are seeing more employers using clawback provisions in their employees' contracts, trying to recoup some of these fees if the employee leaves before the end of the visa term. We can assist or advise on drafting of these provisions, so please do get in touch with us if you need our assistance. Now, moving on to our next topic. The government announced a huge increase in penalties for businesses and for businesses who employ legal workers and landlords who fail to undertake appropriate right to work checks. Now, currently, businesses who employ someone who doesn't have the right to work check without properly carrying out the correct checks can face fines of up to £15,000 for the first offence per worker. Repeat fines are currently at £20,000 per worker. Now, from 2024, these fines are due to triple, with first-time offenders being liable for up to £45,000 per worker and repeat offenders subject to penalties as high as £60,000 per worker. And similarly, the government are also increasing fines for landlords who rent properties to those who do not have a right to work to check, and failing to carry out a right to rent. My apologies. So for the first breaches, the fine per lodger is increasing from 80 to a staggering £5,000, and the fine per occupier is increasing from £1,000 to £10,000. Again, for subsequent breaches are increasing up to £20,000. So if this is of interest to you, we have recently published an article on our website, so please do go along and review the full details of the right to rent schemes. The government seems to suggest that these increases in fines will be a deterrent to people smuggling and the small boats crossing, with the Immigration Minister, Mr. Jenrick, saying that unscrupulous landlords and employers who allow legal workers and renting enable the business model of the evil people smugglers to continue. However, these increases in penalties are likely to impact potentially negligent or even careless organisations rather than those who are deliberately violating the rules, and therefore it may not have much of an impact on these unscrupulous employers referred to by Mr. Jenrick. So note also that businesses who deliberately employ individuals that they know or have reasonable cause to believe do not have the right to work check are already subject to an unlimited fine, and senior staff in that organisation could face up to 5 years in prison. If you would like any advice on your right to work checks and processes, please do get in touch. Callum will discuss more about right to work in a little bit. So Victoria, that brings us over to you for our second poll.
Thank you, Imelda. So our second poll is focusing on the information that Imelda's just discussed on right to work. So from 2024, what is the fine going to increase to for a failure to comply with the right to work checks as a first time offence? The options are £20,000, £35,000, £60,000 or £45,000. So remember, this is for a first time offence. Give you a moment to answer. So it's good, most of you have got that one right, with a few selecting 20 and 35, but the majority was 45,000, which is the right answer. And then the fine for repeat offenders is £60,000. So that's good, so I'll pass back to Imelda.
Thank you, Victoria. Yes, these are eye-watering amounts. We don't yet know when they will come into force, but it'll be at some point in the beginning of next year. Now, let's move on to our next topic. Excuse me. The Global Business Mobility Sponsorship Route was introduced with the aim to reform the immigration system, whilst being able to adapt to business changing needs. Now, many of the requirements are similar to the old intercompany transfer routes. The visas contained within this route can be used by businesses overseas with or without a UK presence, and it will enable them to send their employees to the UK temporarily for a specific corporate purpose. The 5 visas available under this route require all UK businesses receiving workers to register for a sponsor licence. The workers coming to the UK must be paid at a relevant salary threshold and undertake a role at an appropriate skill level, so similar to the intercompany transfer route at the moment. Most workers must be with an existing employee with a minimum length of overseas employment. The assignments will be temporary, but there is flexibility to move. The workers will be able to switch to more permanent routes that lead to settlement in the UK, and there is no need for workers to meet the English language requirement. Now, the types of scenarios that may apply in this route are where an overseas parent company wants to send a worker to the UK, branch or subsidiary, where an overseas service supplier wants to send a worker to a UK client, or an overseas purchaser wants to send a worker to a UK supplier. And finally, where an overseas business wants to send a worker to a UK branch pre-trading. Now let's look at the types of visas. There are 5 visa routes covered under this Global Business Mobility Sponsorship. Now a sponsor will need to have each of these categories on their sponsor licence to utilise the visa routes. So if they don't have the category on the licence, they must apply for the relevant category if they don't have one. The first 3 routes I will cover, you may be familiar with them. They've changed names, but they were formerly intercompany visa routes. The first one is called a senior specialist worker route. This replaces the old intercompany transfer route. It's now referred to as GBMSS. All other aspects are practically the same as the old ICT route, so I won't need to say any more about that. The second one is the graduate trainee route. This replaces, again, the old graduate trainee route on the intercompany transfer. Now, sponsors who had this route on their old licence would have lost it if they hadn't used the route since the licence was granted. They will now need to make a new licence application requiring specific evidence relating to that training programme for their graduates. The third one is the UK expansion route. Now, this replaces an old visa called the representative of an overseas business, which was not a sponsored route initially. The route is available for individuals to set up a branch of their overseas business that has not yet started trading in the UK, and they must work as a senior or specialist manager and have the ability to make decisions about the business. Now, only 12 months are permitted in this route initially, with extension up to a maximum of 2 years. They must then move to another category, such as the skilled worker or the GBMSS, after their 2 years. Now, the last two routes are new routes. The first one is the secondment worker. It can be used by an overseas employer transferring a worker into the UK to do an eligible job for a different organisation. Employers must have a high-value contract with that UK organisation. The investment contract for goods and services with the overseas business must be worth at least 10 million per year and no less than 50 million in total. And before any sponsors can transfer individuals, that contract must be registered with the Home Office on the sponsor management system before the worker applies for a visa. Now, if there are multiple contracts, each of those contracts must be registered separately. A level 1 user, for those who are familiar with the terminology on the sponsorship management system, must apply to make a change and add that new contract if it applies to the sponsor management system, and have approval before any workers can come in under this route. The final route is the service supplier route. Again, there must be a contract in place to provide services to a UK company. Service suppliers can come to the UK for either up to 6 or 12 months per assignment. Now, that will depend on the trade agreement they're providing services under. They must be an employee of the overseas business, or they can actually be self-employed as a service provider based overseas, provided they're established in the country, again, of the eligible trade agreement. They must also be providing a service to the UK business covered by that trade agreement. They must also meet relevant nationality or residence requirements applicable. So, for example, where there's a trade agreement between the UK and Latvia, a Polish national working in Latvia may not be eligible under the terms of that trade agreement. So please do bear this in mind if you want to utilise this route. Excuse me. The Home Office do have a list of trade agreements that are eligible under the scheme, and they're very similar to the old GATS agreements, which were formed under international law through the European Union. Some of these individuals will also need to establish that they have a degree or equivalent or professional experience, so 3 years for an employee and 6 years if they're self-employed. So there are other requirements that these individuals would also need to meet. Now, all of the routes under the Global Business Mobility Visas are subject to a maximum stay in the route of 5 years in any 6 or 9 years in any 10, depending on their salaries. This is because these routes do not lead to settlement, and this does include time spent under the old ICT visa routes. So sponsors, if you are going to employ individuals who are previously on an old ICT route, you need to check that they haven't had previous time, which will bring them over the permitted period. And this is to show that these are not routes to settlement, and individuals can claim time in 5 years for indefinite leave to remain, or 10 years under long residence. Wow, that was a lot to cover. Right, let's moving on to our next subject. So the health and care visa specifically is part of the skilled worker visa. It's open to health and care professionals, such as doctors, nurses, and adult care workers. They must work in the UK for an approved employee, such as the NHS. This visa has been designed to offer a fast track with reduced application fees and no healthcare surcharge fees for these eligible healthcare professionals. Now, earlier this year, the Home Office announced a change in the rules on supplementary employment. This change temporarily lifted the 20-hour cap on supplementary employment, meaning that the eligible workers were permitted to work in a second job for as many hours as they liked without having to update their visa, provided that job was also eligible for the health and care worker visa. Now, this 20-hour cap on supplementary employment has resumed. So workers can do additional paid work as long as they are still doing the job they're sponsored for. They can work up to 20 hours a week in another job without updating their visa. If it's in the same occupation code as the first job or in the shortage occupation. So workers will need to update their visa if they now work more than 20 hours outside of their sponsored role. And they will also have to update their visa if they work less than 20 hours, if the additional job is not in the shortage occupation and in a different job to the first job, or the same occupation but at a different level. If workers do need to update their visa, they may need to approach employers to obtain a new certificate of sponsorship from their employer and apply for a new visa. Lifting the cap gave health workers a flexibility to do unlimited extra hours, but now that these restrictions are back in place, some of these workers will see a reduction in income. And as the cost of living crisis continues, this actually may be very difficult for some lower paid healthcare workers. Employers too will lose the flexibility when offering supplementary employment. They may now need to offer sponsorship instead. Excuse me. We are seeing, and we will see a little bit later, how the government feels about the adult social care sector, but we are continuing to see staff shortages, and they are increasingly reliant on overseas recruitment. So the number of migrant workers coming to the UK under this route has increased significantly over the last year. And according to the Home Office latest statistics, there were over 120,000 health and care worker visas granted in the year ending June 23, which is an increase of 157% compared to last year. 50% of the visas granted under the health and care visa were granted to care workers and home carers, which are two routes on the shortage occupation list. Employers in healthcare, if you are employing individuals using the supplementary provision, please do check that they are meeting the conditions of their stay. With civil penalties set to rise significantly next year, it's really important that you're undertaking your right to work checks, which includes the conditions of their stay. And Callum will talk to you a little bit more about this later on. Let's move on to our next subject. Now, the Youth Mobility Scheme is an unsponsored route, so quite useful for employers in the UK, generally for individuals up to the age of 30 or 35 to come to the UK and work for up to 2 or 3 years. There are currently 12 countries participating, so we have Australia, New Zealand, Canada, Japan, Monaco, Taiwan, Hong Kong, Republic of Korea, San Marino, Iceland, India, and Andorra will join from early 2024. British overseas citizens and British overseas territory citizens may also be eligible to apply for the scheme. Places are allotted annually, with the vast majority going to Australia at about 30,000 places. New Zealand too get about 13,000, Canada 6,000, San Marino 1,000, and India 3,000. So applicants out of 5 of these countries must apply for a ballot, so which is open twice a year, January and July. They get 48 hours to apply. If they're lucky, they can then apply for the visa. So this is a great route for employers to utilise that doesn't require sponsorship, at least for the first 2 to 3 years. There are changes to come into force in January. New Zealand, Canadian, Australian nationals can apply up to the age of 30, opposed to the usual 35, excuse me, opposed to the usual 30, and they can benefit from the 3 years instead of the usual 2 available to most countries. Those nationals, New Zealand nationals in particular, who are granted this provision earlier in the year, can apply for extension if they were only granted 2 years, provided they are in the UK and their visa is still current. We do find a lot of employers ask for assistance on moving Youth Mobility Scheme workers over to usually a skilled worker visa. Note this visa cannot be extended and the time spent on it does not lead to settlement. Now moving on to our next section. There are some salary and condition changes. Again, these are applying to sponsors. The minimum annual salary for the skilled worker has increased from 25,600 to 26,200, and for the global business mobility route, in particular the senior or specialist worker, the threshold has increased from 42,400 to 45,800. The graduate trainee threshold has also increased from 23,100 to 24,220. The going rates for each of the skilled occupations have also changed, but these are too numerous to detail. So if you are familiar with some of the specific occupation codes and you are a sponsor, please do check before you start preparing contracts. Also, the calculation of the going rates for annual salaries is now based on a 37.5-hour week as opposed to the old 39-hour week. So again, you can prorate hourly rates depending on the going rates set out in the occupation codes. As always, sponsor will need to be careful that they not only pay the sponsored workers the annual salary at least as high as both the minimum annual salary and the relevant going rate, but also they pay the relevant minimum hourly rate. The Home Office has recently said that all visas must apply the national minimum wage and working time regulations, or if they believe that any occupations or roles do not meet these regulations, they will refuse an application. Moving on. In 2022, nearly 500,000 student visas were issued. And of course, the number of dependents the students brought in increased by a massive 750%. In response, the UK government has announced several restrictions to the student visa route with the aim of reducing net migration, the mantra since the Tories got into power. These changes are also part of a wider crackdown on overseas agencies who are seemingly advising people on entering into sham marriages so that they could accompany the student applicant with them to the UK. Of course, dependents of students can work in most jobs in the UK without sponsorship and most other restrictions. So for students starting courses on or after the 1st of January 24, they will not be permitted to bring their dependents unless the course is a PhD or other doctoral qualifications. And of course, this is due to the sharp increase of dependent migrants students are bringing into the UK. Students can no longer apply to stay as dependents in work routes. And since the 17th of July 23, students can no longer switch into work routes before their studies have finished. Students undertaking a course at degree or above can apply for their visa before the course finishes, but they cannot start until their course is completed. And PhD students will be allowed to switch after 24 months of their studies. Now, students used to be able to switch up to 3 months before their course is finished. So employers, if you are employing students under that supplementary provision, which they also have, please do check their conditions. Now, students do make a significant contribution to the economy. A report recently from London Economics estimated that the total benefit to the UK economy from 21 to 22 for first-year international students over the duration of their studies was 41.9 billion. And they're estimated to cost our economy about 4.4 billion. So that's a net benefit of 37.4 billion to the economy. Now, if we fail to attract overseas students, this could have a knock-on effect on the British economy. Many students do work during their studies, either to support themselves or to gain experience, which may benefit their careers. But the Home Office is keen to ensure that migrants don't use this route purely to come to the UK to work. Students are permitted to take on a limited amount of work subject to stringent conditions. This is normally 20 hours during term time or full-time during vacation time. The conditions will be set out in their right to work checks, so please do check carefully. And note, for any employer who employs students, please ensure you keep a record of their term times, either from the educational establishment's website or a letter from that educational establishment. And sponsors, please be aware that you must not sponsor migrants until after they've finished their course, subject to the supplementary 20 hours or more they're working for you in a temporary role. We move on to our next change. The Home Office recently announced some welcome changes to the holders of European pre-settled status. So from September 2023, People with pre-settled status under the European Settlement Scheme will automatically have their status extended by 2 years before it expires if they have not obtained settled status. This process will be automated and will be automatically reflected on the individual's digital status. Of course, the reason for this is to ensure that nobody loses their immigration status if they don't apply to switch from pre-settled to settled status. Now, the Home Office intends to take steps to automatically convert as many eligible pre-settled status holders as possible to settled status when they're eligible without needing them to make an application. Welcome news. They intend to make some automated checks of pre-settled status, and there will be safeguards in place to ensure that the settled status is not wrongly granted. And some other changes in relation to the Surinder Singh and Zambrana routes. Not sure if any of you are employing individuals on these kind of routes, but since the 8th of October, these routes closed. The Surinder Singh was available to non-European nationals who were partners of British citizens who were exercising their treaty rights in Europe, and it was their access to the UK. And the Zambrano carers were carers of European national children who had no other rights of residence in the UK. Moving on to our next topic, the shortage occupation list are roles that deemed by the UK government to be in short supply in the UK market, and they are afforded more relaxed rules and eligibility criteria. So since the 7th of August 23, various roles set out on the slide have been added to the shortage occupation list following a review by the Migration Advisory Committee. These additions were welcomed by the construction industry as they had lobbied for inclusion due to staff shortages without access to the European marketplace. Some fishing and agricultural roles are also included. Now, if an occupation code appears on the shortage occupation list, then the worker applying for the skilled worker visa will benefit from reduced application fees, and the employer will also benefit from reduced minimum salaries, normally at about 80% of the ordinary going rate for that role. So these reduced immigration costs may incentivise the recruitment of skilled workers from overseas to fill these shortages, but again, with the rising costs, that remains to be seen. Moving on, unfortunately, most recently on the 3rd of October, the Migration Advisory Committee released some recommendations on the shortage occupation list. Now, very surprisingly, the key recommendations were to entire abolishment of this shortage occupation list, because the Migration Advisory Committee believed that giving low-wage occupations in particular access to this skilled worker route carries a risk of exploitation to the migrant workers and perhaps may make them vulnerable to unacceptable working conditions. And you will see there was a particular focus on the adult care sector, which I will talk about a little bit later. They also looked at role-specific conditions, making recommendations for roles such as lab technicians. They believe that more experience should be required for this role, and they reclassified specifically sommeliers at a different skill level, and they would be required to have more experience in that role before being eligible for the list. There are also recommendations to remove the going rate discount, making all occupations on the national pay scale, mainly applying to public sector workers, ineligible for the shortage occupation list, or where the going rate is above the general salary threshold for the skilled worker rate. They also are making recommendations to allow asylum seekers who have the right to work in any occupation, rather than making them only eligible to undertake roles in the shortage occupation list. And finally, an update on the sponsorship requirements to remove the creative worker route altogether. Of course, these recommendations are still yet to be considered, so we will have to wait and see what happens next year. Let's move on now to sponsorship updates. There have been many changes which will have a direct impact on sponsors, which I see is about 20% of you. Sponsors level 1 users must review the sponsorship management system message board on a regular basis to ensure they're up to date with any changes. There have been some recent changes since October 23. The authorising officer and key contact must provide their national insurance number, and if a level 1 user is amending any details of key personnel, they must also provide their national insurance number. There is a free text box within the portal to add notes in relation to national insurance numbers. If key personnel do not have national insurance number, it may impact the nomination of the role. Since the 8th of October also, sponsors company house reference number has been enabled in the sponsorship management system portal. The company's house reference number will facilitate the Home Office in making any decisions or changes of circumstances that you may have in relation to your sponsorship license. And earlier in March, improvements were made to the sponsorship management system for requests to replace an authorising officer, key contact or level 1 users. These requests would be fulfilled immediately, subject to the matching of the postcodes of the company on the licence or the representative, which is great news. Also from March, the annual allocation of the certificates will automatically renew at this expiry, granting the sponsors the number they've previously allocated. And normally the standard requests for changes on the portal would take up to 18 weeks to approve, whereas there is a paid for priority service, which would take 10 days. So of course, these changes remove the need to utilise the paid for priority services. Sponsors should ensure they're up to date with their reporting duties, both pre and post licence, ensuring that all changes are reported in the Home Office at the relevant time periods, and ensuring their employee contact details are up to date and checked on a regular basis. So a recent example of a change is reporting the change in company size. This must be reported within 20 working days rather than the previous 10 days, or of the event or becoming aware of it. So usually companies' house publication records will give you an indication as to when the size has changed. If the business is heading for a merger or an acquisition, organisations may need to update or even replace their sponsorship licenses. Note the sponsors must report any significant changes within 20 working days. That includes where business is involved in a merger, demerger, acquisition, or where there's any change in ownership. The Home Office has suggested that due to the number of licence applications, they will be conducting more frequent checks on sponsors to make sure they're compliant. They will target sponsors who have not yet received a visit, so it's important to be prepared for a visit. The Home Office can attend at any time during the course of the licence, so it's important that the key personnel details are up to date, including number and the address where they work. The person who is in attendance, so either the key contact or the authorising officer, should be able to explain the processes and find documents in relation to sponsorship if the officer requires them. It's also really important that employee details are up to date and the address set out on the certificate of sponsorship matches where they are, as quite often the officer would like to interview sponsored workers. So if they're on a client site, please ensure your level 1 user updates the portal. There is a new GENUS requirement which will apply to skilled worker applications submitted after the 7th of August. This gives the caseworker a chance to look at more detail in terms of the GENUS of the role and the individual, to make sure they have the skills and the ability to carry out the role, and that they don't intend to take employment other than the role for which they've been sponsored. They can ask for additional information or even request that the applicant attend an interview. So it's important that the individual is aware of the information that has been submitted to the Home Office on their certificate of sponsorship. We're moving on. I will hand you over to Callum now for the right to work checks.
Thanks, Imelda. My name is Callum. I'm an employment and immigration solicitor at Field Seymour Parks, and I'm going to be talking about what right to work checks are, why employers need to do them, and the different types of check an employer can carry out. So to start with, what is right to work? Well, right to work is essentially what it says on the tin. It is the right to do work in the UK. There are various ways that an individual can have this right to work, but there are three main ones that you're most likely to come across. The first way is through citizenship. Of course, a British citizen has the right to work, regardless of whether they're a citizen from birth or acquired the citizenship via naturalisation. But Irish citizens also have the right to work under the Common Travel Area Arrangement, which is a long-standing arrangement between the UK, the Crown Dependencies and Ireland, which predates British and Irish membership of the EU. An individual will also have the right to work if they have indefinite leave to remain in the UK, also known as settled status. Indefinite leave to remain is a form of permanent residence, allowing the holder to remain in the UK without any restrictions. It is ordinarily acquired after living and working in the UK for a continuous period of 5 years. An individual can also have the right to work under the terms of their visa, whether that be a work visa authorising them to work for one or any organisation, a student visa allowing them to work on a part-time basis, or a family visa. There are also other less common sources of right to work status under the EU settlement scheme, the Commonwealth right of abode, refugee status, and others. Moving on. Employers are required to confirm that all prospective employees have the right to work. Employers must not discriminate against employees who they feel do not look British or Irish by only carrying out checks on them. Right to work checks must be carried out on all prospective employees. Employers must carry out these checks before the employee commences work. Where the employee is on a time-limited visa, the employer must also repeat the right to work checks at the end of the visa, or they might lose the statutory excuse provided by the right to work check that they carried out when the employee first commenced work, and thereby risk a fine for illegal working. Now, as Imelda mentioned earlier, there are strict penalties for employers failing to comply with their obligations. If an employer employs an illegal worker and they knew or had reasonable cause to believe that this worker did not have the right to work, the employer may receive a prison sentence of up to 5 years and an unlimited fine. And if an employer fails to do the correct right to work checks and unknowingly employs an illegal worker, they will still be liable for a fine of £15,000 for a first offence and £20,000 for each repeat offence. And as Imelda mentioned earlier, these fines are set to triple. From 2024, first offenders can be fined up to £45,000, with repeat offenders risking fines of as much as £60,000 per illegal worker. And that's why it's absolutely essential that employers carry out these checks properly. On to the next slide, which I think Victoria might have a poll for us first. Is that right, Victoria?
I believe so. Wait for it to come up on the screen. Yeah, so this is going back to Imelda's content on shortage occupation list. So the question we have is, which one of the following occupations has recently been added to the shortage occupation list? So we've got veterinarian, engineers, bricklayers, and IT experts. I'll give you a moment to vote for the answer. Well done, everyone. Most of you got the right answer, which is bricklayers, which is one of the recent changes, along with masons, roofers, and other occupations. So I'll hand back to Callum.
Thanks, Victoria. So since the 1st of October 2022, there have been 3 types of right to work checks that employers can carry out. These are the online home office checks, manual checks carried out in person, and checks using an identity service provider. If an employer carries out one of these checks in accordance with the guidance and the code of practice, then they will establish a statutory excuse protecting them from the penalties that we mentioned earlier. Moving on to the online home office checks first. Employers don't need to obtain any documents to carry out the online home office checks. All they need the individual to provide is their date of birth and share code. The share code is generated by the individual, who inputs details from their electronic visa or biometric residence permit into a website to generate the code. They can then give this code to the employer so that the employer can carry out the right to work check online. However, employers cannot require individuals to generate a share code or to use this service. If an individual refuses to do the online checks, then you will need to carry out your right to work checks manually. In addition, a share code can only be generated using details from an electronic visa or biometric residence permit. So if an individual derives their right to work from some other source, such as their British citizenship, for example, then they will not be able to generate a share code and you will not be able to carry out an online check. The main alternative to the online check is a manual check of the documents evidencing right to work status. Moving on to that now. During the coronavirus pandemic, these checks could be carried out over a video call. However, these adjusted checks were ceased on the 30th of September 2022. Now, all manual checks must be carried out in person and face-to-face. There is Home Office guidance, called Annex A, setting out the documents required for these checks. This guidance can be accessed online by searching for Right to Work Annex A. Please note that biometric residence permits are not acceptable as Right to Work documents for manual checks. So biometric residence permits must generate a share code to prove their right to work status online. The employer must check that the documents in question are genuine and that photographs of the individual on the identifying documents match their appearance in real life. The employer must also confirm that the right to work status granted by the documents has not expired, and that any restrictions that apply must not prevent the individual from doing the intended work. If there are any differences in the names used across the documents, then this must be explained, and supporting documentary evidence must also be provided and checked. For example, a marriage certificate to explain a change in surname. Having carried out the checks, the employer must then keep copies of all documents checked. These copies must be retained throughout the individual's employment and for at least 2 years post-termination of their employment. And next, we'll move on to using an IDSP, which is the third option. So this is a new option available to employers carrying out right to work checks to engage the service of an identity service provider, or IDSP. IDSPs use identity document validation technology to confirm the validity of the documents evidencing right to work status. The Home Office have produced a list of certified IDSPs who have received certification from certifying bodies confirming that these IDSPs carry out checks in accordance with guidance. Now, there is no requirement for employers to use a certified IDSP for their right to work checks, but it will provide more assurance that the IDSP is doing things correctly. The IDSP option is still relatively new, and employers are currently weighing up the pros and cons. On the positive side, the Home Office hopes that IDSPs will reduce human error in right to work checks, and for some employers, engaging an IDSP to carry out bulk checks may be more cost effective than the admin involved in the employer carrying out checks itself. However, IDSPs do charge fees for their services, and these fees are often structured in such a way that it is only worth engaging them if you require a large number of checks to be carried out. Further, employers still need to carry out due diligence to satisfy themselves that the IDSP is carrying out the checks correctly, and they need to retain copies of these checks. So using an IDSP does not completely eliminate admin costs for the employer. The scope of using IDSPs for right to work checks is also quite limited as it stands, as currently IDSPs can only be used for checks on British and Irish passports. So employers cannot use an IDSP if the individual's right to work derives from an indefinite leave to remain or a visa. And I think we'll quickly go back to Victoria for our fourth poll.
Thank you, Callum. So this is our fourth and final poll regarding obligations on employers. So when must an employer check an employee's right to work status? The options are before employment commences and at the end of a visa term, never, or when a visa term expires. So I'll give you a moment to respond to the poll. Apologies everyone, I think we're just experiencing a few technical issues on the slide, so you don't take too much notice of those. So we have the results. The majority have got the correct answer. So before employment commences and at the end of a visa term. So it's important that it's done at both times. So I'll back to Callum.
Thanks, Victoria. Now, obviously, I've gone through the 3 types of check that you can do, but there may be circumstances in which the aforementioned options are not available. So you might be asking, what if my prospective employee is waiting for a decision on their visa application, or what if they're waiting for their biometric residence permit to arrive? In situations like these, an employer can use the online employer checking service, provided they have the permission of the individual in question to do so. The employer will also need the employee to provide personal details, including their full name, date of birth, nationality, home address, and any Home Office reference number or case ID. These details should then be provided on the ECS site, along with the employee's job title and hours worked per week. If the individual does have the right to work, the employer will be sent a positive verification notice, which provides them with a statutory excuse to employ the individual for 6 months. And this should be enough time to cover any wait for a visa decision or biometric residence permit. Please note that where a migrant worker's visa has expired and they're renewing their visa or obtaining a new visa in order to work for the employer must obtain the positive verification notice before the 28th day after the original visa expired. And now I'll hand back to Imelda to talk about the new ETA.
That must be the most famous expression over the last 2 years. You're on mute. Apologies. Right, now to talk about the Electronic Travel Authorisation Scheme. This scheme is to screen travellers before arriving in the UK. It's a digital permission to travel, and it will be required by all non-visa nationals coming to the UK except Irish and British citizens. Those coming for 6 months as a visitor, including transit, or those coming for 3 months on the creative worker visa concession. Those who do not need to apply for a visa currently in advance of travelling will now need to apply to travel in the scheme. So those that come through currently, like US nationals, European nationals, or Australian nationals, they could go through e-gates, have 6 months in the UK and undertake activities as permitted under a visit visa. So these applications, decisions, we are being told will take around 3 working days. However, if further checks are required, maybe when someone has an adverse immigration history or a criminal record, checks may take a bit longer. If these applications are refused, those individuals may need to apply for the appropriate visa instead, which is potentially a standard visit visa, a transit visa, or some form of temporary work visa as relevant. The ETA will cost £10 per applicant, and it will last 2 years unless the individual's passport expires sooner or they change their passport, so it's linked to a passport. Moving on, the scheme is gradually been introduced for nationals of different countries in different stages. So currently, Qatari nationals will need to apply to travel to the UK on or after the 15th of November, and applications will open to them on the 25th, or did open to them, excuse me, on the 25th of October. Nationals from Bahrain, Jordan, Kuwait, Oman, Saudi Arabia, and the UAE will need to apply for an ETA from the 1st of February 23 for any travel on or after the 22nd of February. And further countries are expected to be subject to the scheme in due course. We are expected to see the implementation for all nationalities by 2025. There is a similar scheme which will operate for entry into Europe called the European Travel Information and Authorisation Scheme, or ETIAS. The ETIAS, like the ETA, it's a similar scheme for individuals to enter Europe as a visitor. Again, it's digital permission to travel, and it will require all British nationals, including some other non-European nationals, to travel to one of 30 European countries. There is a list on the Home Office website, which will include all European countries with the exception of Ireland, just under a different scheme. Individuals with European passports will not need to apply to the ETIAS. It's expected to come into force next year. Precise details of when and how we're not quite sure of, but we expect it to align with the ETA for the UK. Applications will take minutes, we are told, similar to the American ESTA system. But again, visa refusals or any adverse immigration history may cause further delay. They are hoping the scheme will, the visa decision would come within 4 days, but again, up to 30 days if additional checks are required. Some applicants may also need to attend an interview, again, very similar to the American scheme. If these applications are refused, details will be provided at the time of refusal with appeal options or other visa options. The applications will cost slightly less than the ETA at £7 per applicant, and it will last 3 years as opposed to the 2 years for the ETA into the UK. Obviously, again, they're linked to a passport, so if the passport expires or if it's lost or if it's changed, a new ETIAS will be required. Now, what does this mean for employers? Employers arranging travel for business for staff to the UK or European countries should be aware that some nationals will be required to obtain relevant permission to travel or even visitor visas. So non-visa or visa exempt nationals will need to apply for the scheme. Employers should perhaps take extra time to arrange travel and factor this in if they're managing trips, so that the visa permission can be required in advance. And similarly, if visas are refused, employers should be aware that they may need further time to apply for other types of visas, which particularly into Europe may need advice from immigration practitioners. So I think that is all I have to say on the electronic travel authorisation. Let's moving on to our final slide. So there has been a huge focus at both the Labour and Tory conferences recently on immigration. It's a hot topic. There's a bun fight going on in the Tory party at the moment, with Suella Braverman being sacked and the latest decision from the Supreme Court making the Rwanda removal illegal. Of course, at their conferences, there were discussions on net migration. This has been the mantra of the Tory party for, I think, almost a decade now or more. There were discussions about the skills agenda. Both parties want to ensure a strong domestic workforce without relying on international workers. There's also a consensus that roles in the shortage occupation list should no longer benefit from salary concessions or be eligible for sponsorship. And we have already seen that the MAC proposed to abolish the shortage occupation list, but we will have to wait and see what happens there. The Immigration Minister, Mr. Jenrick, advised that they will continue to seek to cut dependent family members. We've also seen the changes in the student route, only permitting dependents on PhD students. Another area of focus, again, at both parties was the health and care social visa, which we saw had a massive increase in recent months. And they feel that there's also the potential for abuse in modern day slavery of workers that are coming to the UK, particularly in the care sector. We as a firm are already seeing requests for additional information for sponsors in the social care, adult care sector, where we need to provide much more information to the Home Office to approve certificates of sponsorship for candidates overseas. What's next? Yes, there were also concerns raised about the lack of investment in local skills and recruitment, meaning organisations must rely on recruitment from overseas. So I found that immigration is a hot topic basically for both parties, and with a general election coming early next year, we don't know what will happen, but we feel that whoever gets into power next, there will be changes across immigration. So we'll be prepared to be very busy. Looking ahead at the introduction to the new IT programme, which is to streamline the licence application process and include automated checking. The Home Office agreed to invest heavily in changes to make the system a bit more user-friendly, reducing the admin for both employers and practitioners. The latest edition of the Company House number will allow checks against Company's House to ensure the correct information has been submitted as part of the licence application or any updates. And the Home Office do check Company's House before they approve requests. We have yet to see the automated updating of visa applications, but we're hoping this is still to come. The cap for pre-licence priority services have increased from 10 to 30 daily. The system for requesting is now sitting on the platform, but we are finding they're still so difficult to obtain. We suspect it's the number of people hitting the system at 8:59 to 9 AM. And from our experience, normally slots are gone by 9:01. Well, we have had success recently, Callum, haven't we? Which was great after trying daily for, I think, about 3 weeks. The post-license priority slots have also increased from 30 to 60 per day. However, the automated changes that I spoke about earlier have made these requests less likely, with quite a few being automatically updated on the sponsorship management system. In compliance, the Home Office has said they will increase the number of visits. So sponsors, please ensure that you're up to date with sponsor duties, ensuring you have all the information up to date and addresses, individuals, information is up to date, etc. The Home Office will always check HMRC records to ensure employees are paid correctly. This also looks for students potentially who are working over the hours permitted. So please ensure again that the conditions of visas are also being checked in line with right to work. We find that some sectors are targeted, such as retail, hospitality and the care sector, because they feel that these areas need more scrutiny. I mentioned earlier, the immigration healthcare surcharge increases by a massive 66%. So if you are undertaking recruitment, please do check now that you have the budget to make those places or to allocate those roles in January. Also mentioned earlier, again, we have an increase in clawback provisions. They are becoming more common in employment contracts. We are asked to draft numerous different variations so that employers can claw back some of these fees. That's if they are paying them out in the first place. So please do get in touch about those. And finally, I just spoke about the ETA and the ETIAS. If you are sending your employees for business travel and they don't hold British passports going into Europe, or vice versa, European passports, please do check on the requirements for visas under the ETA, ETIAS scheme for next year. And the final point to looking ahead for next year, again, I spoke about these earlier, but under the trade agreements after Brexit with Canada, Australia, New Zealand, these nationals now will get 3 years in the UK under the Youth Mobility Scheme, and they can apply up to the age of 35. So I think that concludes what I have to say, and we will open the floor to some questions. Well, not open the floor, but we will look on the chat for any questions. So if you have raised any questions, we will now have a look on the chat. Victoria, can you see what questions we have there?
Just looking at the chat just now. Yeah, I think there's a question about compliance with sponsors' reporting duties, Imelda.
Oh, wonderful, I'll take that one. Okay, so failing to comply with sponsorship duties could result in a license being suspended, downgraded, or even revoked. If the license is suspended, the Home Office will normally undertake a review of the processes and procedures, ensuring you're complying with more or less all duties. And depending on the outcome of that assessment, they may downgrade the license, or they may put in place an action plan at a cost to the sponsor, setting out how you can improve to be upgraded again. They may also revoke the license, and if a license is revoked, all sponsored workers would have their leave curtailed to 60 days, meaning they must apply for a new role in the UK or leave the UK. So there are quite serious consequences depending on the severity of the breach as to what the Home Office will do. And it's also really important that as a sponsor overall, that sponsors are also complying with right to work checks, because there is an overarching obligation to comply with all immigration law as a registered sponsor. Is there anything else, Victoria?
There was a question about the cost of the immigration health surcharge, what it will go up to.
Right. Okay. Well, yes, the immigration healthcare surcharge is a fee that individual migrants pay to access the National Health Service, and this fee is being increased incredibly, up by 66%. So this fee should really be paid by the applicant. However, some employers pay it on their behalf, and from next year, this fee is quite a bulk of the visa application fees overall. So quite often employers may want to help their employees pay and perhaps ask the employees to pay it back, or there are various ways in place, but it does considerably increase the cost of visa application overall.
Thanks, Imelda. I don't think there are any other questions at the moment.
Terrific. Okay, well, if that's all, I think it's just left for me to say, really, thank you. Thank you for your time. Thank you for participating in the polls. Our contact details are on the screen now, and obviously the slides will be sent to you together with the, oh no, my apologies, the slides won't be sent separately. They are available if you'd like to download them on the chat now. A recording will be sent to you, and hopefully you can still follow the presentation by moving the slides around. So again, apologies for that. Our email details are here, our immigration page is here. Please do reach out to us if you need any assistance. Thanks again and happy Christmas, and please, we have a feedback questionnaire coming up next. It'll pop up automatically on your screen. Those who respond will be entered into that prize draw for our £50 John Lewis voucher. So thank you again from all of us, and happy Christmas to you all. Take care.